Welcome, everybody. Thank you so much. Yes, I know you've all been waiting for the regulatory panel. 4 lawyers walk onto a stage. So yeah, we're really going to knock your socks off today. We have an amazing panel. I guess I'll let our panelists kind of give just a very brief introduction about themselves and a bit of their career, and then we're going to launch into some really interesting topics. So Lee, can we start with you and we'll just move down this way?
Sure, thank you, Georgia. My name is Lee Schneider. I'm a financial services and technology lawyer based here in New York. I've done all different kinds of things in the regulated space, and I've been a blockchain lawyer for a number of years now, and trying to figure out where the regulated space and the unregulated space exist in blockchain. I also do a fintech podcast with Troy here, so if any of you are interested, Appetite for Disruption is on iTunes and other places. We talk with a lot of people in blockchain, but a lot of other areas as well.
So I'm Troy Paredes. I now have my own consulting practice doing financial regulation, compliance, governance, a fair amount, as you might imagine, in the crypto blockchain space, fintech, reg tech, and the like. Before doing that, from 2008 to 2013, I was a commissioner at the Securities and Exchange Commission. If you rewind the clock a little bit, I was a law professor, and at one point earlier, I was a deal lawyer. So it's great to be here again. Looking forward to it.
Thanks, Georgia. And I'm David Felsenthal. I'm a partner at Clifford Chance. I'm also a financial services lawyer. And in this space, we've been working a lot with issuers who are trying to access the market in a completely compliant way, as well as with more traditional banks who are just interested in using the blockchain for their existing securities and seeing how they can make the ecosystem work for them as best as possible.
And I'm Georgia Quinn, General Counsel of CoinList. I'm a securities attorney, started at a firm called Weil Gotshal, then co-founded a company called iDisclose that automates securities filings, and now am in this fascinating new space. So as Amy mentioned, there's a lot of discussion about the Howey Test, and frankly, you guys are probably pretty sick of talking about it, so we're not going to dwell on that. But we are going to touch a bit on what is a security and what is not a security. And this was very important, and the subject of a lot of discussion several months back, and then it kind of died down, and people were just accepting that most of these sorts of tokens were securities. But now we're seeing a lot more activity and discussion about where that line is actually drawn, and if something can convert once it, after initial issuance, once the network is up and running, can it then convert into a non-security? We have Mr. Hinman from the SEC giving a speech, discussing some of those points. And then most recently last week, Congressman Davidson submitted a letter to the SEC requesting guidance in this area. So Lee, we don't need to go again through the Howey Test, but why is this an important discussion, and what are your thoughts?
So a couple things. First of all, the thing that I like to remind everybody about Howey, regardless of what the test says, is the Supreme Court definitely did not say that oranges were securities in the Howey case. It was all about an investment contract related to oranges. And this is an incredibly important point, because I think oftentimes we've gotten away from looking at what is the token really, whether that token is in existence when it's sold or not, and thinking about whether or not the features of that token make it a security. I mean, we can certainly say that if the token represents shares in a company, equity in a company, that's going to be a security token. And a lot of the things that the prior panel and the prior panels have been speaking about all apply in those cases. Where it gets harder is where the token is not a typical form of security that we're familiar with. And I think that's the area where a lot of people have trouble. Just a quick example of that, the way that I like to think about tokens is that they are a digital representation of something. And we see digital representations every day in our lives. For example, I was on Amazon the other day buying a new pair of shoes, and I looked at a lot of digital representations of shoes. I didn't once think that those digital representations were securities. I thought that they were shoes. And we need to sort of bring that same kind of thinking to blockchain, in my view.
Great. And Troy, from a regulatory perspective, how might a regulator look at this, and why is this such a difficult issue?
Wow. So try to be brief. A few thoughts here.
In 1 minute.
Yeah, in 1 minute. All right, I'll keep an eye on the clock here. So one of the reasons is because the stakes are so high, right? And the stakes are so high, and the prior panel touched on this as well. The stakes are so high because if it's a security, you've now triggered the totality of the federal securities laws. Now, if it's not a security, you may have triggered other regulatory and legal regimes. And quite frankly, even if you trigger the entirety of the federal securities laws, you may, in addition, be triggering lots of other regulatory regimes, set aside things like tax and what have you, which is table stakes in terms of that's always going to be present. So this question of, is it a security or not, is a threshold jurisdictional question as to whether or not you have to worry about and focus on all aspects of the federal securities laws. And we've seen that underscored. The discussion around Howey tends to, I think, get people focused on what the regulatory requirements are in order to conduct the offering. But another important aspect of it, of course, is, well, if it's a security and if you're facilitating the offering of it, well, are you now a broker-dealer? And then you trigger the entirety of the broker-dealer regime. And even if you set aside tokens, there's still a lot of questions around what exactly is or isn't a broker-dealer, finder, et cetera, and all the rest. So you have that kind of threshold triggering aspect to it, which makes the stakes incredibly high. The other quick point I'll just make is this, is to Lee's point, I think it's important not to get too distracted by whatever you call the thing. Call it whatever you want to call it. The question is what are the economics? What's the substance? What are the real substantive features of whatever the thing is? That's really what the Howey Test says. Whether you like or dislike the Howey Test, whether you agree or disagree with how it's been applied, it's to say, look, we're not going to focus too much on labels. Fair enough, it's an investment contract, but it's a capacious, flexible concept. It's really about what is this thing in terms of its substance and its economics. And that's, I think, where the regulator is going to continue to be focused. Why do I think that? Well, because they've said that and they've made it clear, not just in terms of speeches, but they've also made it clear in terms of backing up what they said with enforcement actions which continue to come out. The question of whether or not you can, if you will, be a security one day and not a security down the road, fascinating question. We can come back and talk more about that, but I do think that's one of the interesting things. One of the reasons it's so interesting is, one, it changes the kind of do you trigger the regulatory regime analysis, but number two, that's something that, at least as I think about it, the commission hasn't had to focus on. Ever. And so this is a brand new, if you will, kind of conceptual question, but it's also stemming from the new technology. That's something the regulator is going to want to be very judicious about in terms of thinking that through before they make any either big grand pronouncements, which I wouldn't expect, or even specific judgments when it comes to things that come before them.
Okay, so I definitely want to put a pin in that because a lot of thoughts on that issue. But while we're just on the topic of regulation more generally, we have a lot of laws in this country already. So in this new industry, do we need more, David? Do we need to add to those rule books, or do we need less? What are your thoughts?
Well, certainly sounds like you've got a position by the way you asked that question, but I guess I don't focus
No,
so
I'm
much.
a lawyer. I want lots of laws.
Oh,
More.
I don't know about that. Anyway, I wouldn't focus so much on more or less. I think what strikes me most about the regulation overall that we've got in place is that it's very focused on regulating intermediaries and the roles and responsibilities of intermediaries. And you know, the blockchain and tokens are just not about that. And I think today's panel, actually the panels we've heard so far, have been a great illustration. I mean, one of the speakers got up and defined the blockchain as transfers without intermediaries. And then the last panel we just heard was about transfer agents and custodians who are in fact intermediaries, who are in fact required. So you've got a fundamental tension there with the rules and how they interact with blockchain. Now that is something I think all of us would like the regulators to address. How do we have smart contracts on the one hand, but have registered transfer agents who have to be responsible on the other? And that's a tough issue. I don't think there are easy answers, and I don't think, to the earlier panel's point, I don't think we're going to get a simple answer out of the SEC anytime soon. But I think it's incumbent on us to work with the regulators and to propose things that can be done to address the concerns behind it. And again, obviously we talked a lot about transfers to accredited investors, and we've heard about different systems. I think from a regulator's perspective, and I defer to others on the panel, but there are issues there. There are issues about how do we as regulators verify what's essentially a systems-based response to a requirement. I mean, the regulators like us here are mostly lawyers or academics who are less focused towards the IT side. How do we make ourselves comfortable? And that's not just an immediate verification issue at the time of being put into place. It's an ongoing problem. We want to incentivize people to continue to comply. A lot of the way that the securities markets work now is you have people like broker-dealers, banks, and so forth, whose whole franchise depends on ongoing compliance and showing ongoing compliance, showing that they do well in the exams. So they have a built-in incentive over time to comply with what an earlier speaker referred to as both the letter and the spirit of the law. How do we build that into the blockchain? It's not easy to answer that, but that is something where I think the regulators could be more interactive and there could be developments.
I think, I'm sorry, Georgia,
No, please.
if you don't mind. I think David's making an excellent point about intermediaries. And some people who might be blockchain purists would say, well, blockchain is trying to get rid of all of the intermediaries. Other people, myself included, say from a practical standpoint, we're going to have intermediaries because people are not always going to be comfortable doing everything themselves. I for one, fall in that category in a lot of areas in my life, right? And so thinking about how to regulate intermediaries is a very important part of what regulators need to do, what the industry, what different industries need to do. But the further point is to recognize that in situations where intermediaries aren't involved, do we need to impose an intermediary for some reason? And that's going to be a really difficult discussion to have. There are going to be people who say, absolutely not, I want to do my stuff on my own, on the blockchain, leave me alone. And there are going to be other people who say, wait a minute, the only way to impose fairness here is if there is a regulator, and how are we going to have that work? Or some other intermediary, and how are we going to make that work? So to me, that's a very, very important tension to think about here.
And if I can just add one thought to take one step back, which is the regulators have certain regulatory goals and objectives that they think need to be met. And they have regulatory regimes. Now we can, again, talk about whether we think they have the right regime. We can have that discussion about the stuff that people have been doing forever versus the stuff that people are doing now, crypto blockchain, right? These debates about is the regime calibrated exactly the right way go on and on and on, and have been going on and on and on, and I think that's constructive and helpful to the process to trying to get it right. But the regulators have certain objectives and goals. And I think it's important to be mindful of that as well. So whether it's there are going to be intermediaries and they're going to be different, what's that regulation going to look like, whether it goes to anti-fraud, anti-manipulation, whether it goes to, well, are the assets actually there when investors want them, which is the core question when it comes to custody, whether it goes to, well, is the process by which the asset goes from person A to person B, is that going to be smooth and frictionless and done in the right way, and everybody have the title they're supposed to have and the money go, right? These are basic, we can go on and on, regulatory objectives and interests that the regulatory regime is designed to address. And I think there's a lot to all of that. I think where that then leads us to, and the others have made reference to this, is all right, to the extent the regulatory regime right now doesn't fit so well with the technology, are there better ways to shape the regulatory regime to continue to advance the regulatory goals? And I think the answer to that is going to be yes, because of the nature of the technology. Lots of things will be able to be done leveraging the technology that allows for some more flexibility or other changes to be made to the regulatory regime. But the way that works itself through, as David was mentioning, is the engagement with the regulator to get them to understand exactly what those refinements are. That is a process. There's lots of mechanisms to facilitate that process, but that's the process. But I say all that to come back to, I think, is the most important point, which is not overlooking the regulatory objectives that they're focused on looking to advance and certainly don't want to have compromised and orienting a lot of the discussion around those objectives, and I think that's a good way to make progress.
And one other point that I'll add to what Troy said, the question of whether or not a token is a security, which then leads us to certain regulatory outcomes, is sort of one of the linchpins here. We may nevertheless decide, even if the tokens are not securities, that we need to regulate the intermediaries that are involved in that, or we need to impose intermediaries into that space. So these are not two entirely separate questions.
Right, and just to put a little more practical guidance into what you guys are saying, because I think this is extremely important, and it's really getting to how we can help the regulators almost. What are your thoughts based on your experiences in working with regulators and addressing these really, frankly, gray areas? Are you guys more of the ilk to create a framework and go forward and have something more concrete as a proposal and kind of ask permission, or just go and simply ask for guidance?
I'll speak for us. I mean, I think in general, the regulatory process is very slow. If we have a specific issue or a specific client who needs to get something done in a realistic time frame, really, I think the way forward is to come up with a proposal that meets the rules and move forward with that framework. I mean, it is a useful exercise to try to educate the regulators and work with them over time. I just think that's a very long-term time frame. At least for us as a law firm that represents specific clients, we just have a hard time operating that time frame for any given project.
I mean, look, I certainly have part of me that says we should just go friggin' do stuff and see what happens. But I'm also a lawyer, and so I tend not to give that as legal advice to my clients. But I want to make a slightly different point, which is getting back to this idea of, well, what exactly are blockchain tokens, right? Blockchain is a technology. And like any other technology, it gets implemented in different industries. And so when we're thinking about how to quote unquote regulate blockchain, one of the things we have to think about is what is the industry implementation? If we're thinking about how blockchain works in the healthcare industry, we need to be cognizant of all of the rules and regulations around healthcare. Same thing in the auto industry, and you can go down the list. And all of those industries are already regulated places. So it's to my mind, a little bit of a difficult thing to say, well, blockchain just means that there's no regulation. We all know that that's really not true. But we do need to, again, to my earlier point, to my mind at least, think about, so what's going on here? What are we doing with this technology? And then let's think about, well, all right, if that's what we're doing with it, how is that activity already regulated? And let's start with some things that we already know are in existence so that we have some grounding in the existing world.
Right, so, and it's more complementary. It's really not a vacuum. There's a whole framework there in all of these different industries. I think that's a really important point. And I think everybody in this room right now is here because they understand compliance, they want to follow regulation. Everybody who's having a coffee break right now, maybe not so much, but that's what's really helpful about this panel, because we can provide some real concrete guidance, for those who realize the importance of it. Okay.
Can I just add, I mean, yes. One specific example just to that is that for us, for example, we're expected to give opinions about securities offerings being regulatory compliant. And we've had a couple instances now where people have said to us, yeah, we've got the smart contracts in place, you can use that. And for us as lawyers, and I think the same apply to regulators, we are still just grappling with what does it mean to give an opinion based on a smart contract. And that's, again, just an example of a place where we need to interact more with the software, with the developers to understand what's going on.
Plus, even just on something like smart contracts, if you look at that through a traditional compliance lens, anytime anytime any institution is leveraging technology and applying technology, set aside what purpose, there's a whole host of questions that go around that regulators focus on. I mean, the simplest one is, what kind of testing have you done? And do you do that testing on an ongoing basis? I mean, that's the simplest, right? So, but again, I think, Georgia, to your point is, if you think about, and Lee, to your point, if you think about the regulatory construct that's in place, that gives you, in fact, a lot of guidance. It may give you more than guidance. It may give you flat-out requirements, right? But there is a lot there that one can already draw from in order to try to figure out what you need to do in a way that's going to meet the requirements you're subject to, and quite frankly, may otherwise just be good business practices and good overall risk management.
Great. Thank you, guys. I want to shift the discussion just a little bit, and our discussion thus far has really been focused on the U.S. regulatory landscape, and we talk to a lot of issuers at CoinList that say things like, well, if I only offer my tokens to foreign investors, then I don't have to worry about securities laws. Or if I incorporate my company in Malta, then I don't have to worry. David, is this an accurate assessment of the law?
Again, that's a tendentious question there. No, fine. I think there are two sets of issues. I mean, the first is the obvious one, which is other countries have securities laws too. Now, I will say other countries tend to be more relaxed about characterizing tokens as not being securities in general, but there are exceptions. There are quite a few countries that still do treat them like the US does. So you do have to think about what's going on outside the US in the local jurisdictions. And then the second point is that even if you're outside the US, the test, the securities law test for what it means to be outside the US is strict and can be interpreted in different ways. And you can't take it for granted that because you've got an offshore issuer, that alone means you're outside the US for securities law purposes. And I promise not to get too granular, but there was a recent case called In Re Tezos in which the court looked at, among other things, where the validation nodes were located for purposes of determining whether an offering was in the US or not. And in the context of this offering, which involved payment through Ethereum, the fact that there were validation nodes in the US shouldn't have come as any surprise, but that was used then to overlay US jurisdiction on the offering was, I think, surprising for a lot of people. So there is this whole question of what does it mean to be outside the US, in addition to, how does the foreign regulation work?
So Troy, we have a lot of jurisdictions out there that are kind of scrambling to develop their own laws in this area and promote their jurisdictions as a safe haven or a place for innovation. How does that interplay with the U.S. securities laws?
It's a great question. Well, David answered it in one respect. Let me answer it in a different respect, which is, I think that from a policymaking perspective, whether that's the ways in which Congress is focusing on these questions or the regulators are focusing on these questions, that one of the things that ought to be in people's minds, I think it is depending upon the U.S. approach to regulating the space, that's going to have an impact on where the economic activity takes place. We have to recognize that, and again, this is not unique to blockchain, not unique to security tokens, not unique to cryptocurrencies more broadly. You can say the same thing about a whole lot of stuff, like derivatives and how you're going to regulate them under Title VII of Dodd-Frank, right? So there's a lot of points of commonality here. But that has to be taken into account. Now, that's not to say that you then just let it rip. But it is to say that you need to be mindful of the ways in which the marketplace itself is dynamic and who's engaging in what activity where with respect to what is a function of the regulatory environment around the globe. And so you have to think that through and figuring out, all right, if we regulate this way or if we don't give that particular guidance or if there's a lot of uncertainty, how is the market going to react? And is that on balance a good thing or a bad thing? And how do we then bake that into our judgments here in the U.S.? And I'm sure other jurisdictions are engaging in a similar type of analysis. So it's hard to say in the abstract where that leads you exactly, but it is certainly part of the mix in addition to the things we've been talking about in effect so far this morning, which is, all right, the more granular, detailed stuff. This bigger picture kind of international dynamics piece is certainly part of the mix.
And I would just add one point to that, which, to follow on the very last thing Troy just said, blockchain is this truly international phenomenon in a way that I kind of feel like many things have not been. And so if the regulators are not trying to learn from each other, then I think that's going to make it very much tougher for blockchain implementations to really be truly decentralized and truly global in nature. Speaking personally, I think that would be terrible. So I heartily endorse regulators talking to each other and learning from each other, and hopefully eventually developing some common standards so that that truly decentralized blockchains can flourish and be beneficial to people all over the world.
On that last, on the last point, I agree. I think there should be lots of discussion and sharing of insights and understanding. I think that's really important because no one has all the answers, to be sure. I certainly don't have all the answers, that's for sure. But on the question of common standards or approaches, because a lot of people raise that question, harmonization oftentimes being the buzzword, one thing I think that's just worth noting, which is more pragmatic about all this, is even if you have 5 jurisdictions, right, and they have the same standard, right, so you hold up the written page and it all says, these are our rules, these are our standards, the life that those standards or those rules or those regulations are going to be given, jurisdiction to jurisdiction, is going to be very different. One reason it'll be very different is because the enforcement mechanisms are going to be different across jurisdictions. There's a whole host of other reasons that it's going to be different. So I just think as one thinks through, the commonality of standards and the kind of that international aspect of this from that perspective, to realize, one, I'm not sure we're going to see a common approach. We haven't seen that when it comes to the rest of our capital markets. But even number 2, even if the words on the page are the same, they're going to play out in very different ways, which then challenges the question whether or not you've in fact achieved the harmonization that you thought, simply because everybody's holding up the same rule or set of standards.
And I think we've seen that with the Basel III standards. I think we've seen that with anti-money laundering standards. Right. You can point to a whole bunch of examples where the words look pretty darn similar, right, especially when they're translated. And then, but the application is different. Yeah.
Well, that doesn't seem very optimistic. But I have not lost hope because we have examples. There's the internet, and most countries do have that, and these companies are able to operate their businesses throughout. So don't lose hope, folks. The name of this event is the Security Token launch event, Security Token being the key element. What are the advantages of tokenizing these assets versus just issuing a more traditional type of security? And Lee, I'll let you start.
Sure, so I'll focus on what I would call traditional securities like common stocks. I think there's a number of advantages. First of all, the last panel I thought did a really good job talking about how settlement will be much easier for transactions, how understanding who your shareholders are can be made much easier through blockchain and related means, and just generally moving away from highly centralized and complex systems to more decentralized and hopefully less complex systems for securities. So I see lots of benefits from a technology standpoint that flow from it. I don't know that changes anything from a regulatory standpoint with regard to common stock and how it's sold, et cetera, et cetera. But if you can clear out some of the underbrush and make it cheaper for people to transact, that's generally a better outcome.
You guys have any additional thoughts?
Yeah, I would also say that one advantage from our perspective is that given the history of security tokens and given sort of the ingenuity involved, there's much more flexibility in tailoring the economics of the token to the what the issuer needs. So I recognize that's not a necessary link to the technology, but in practice, I think it is something we're seeing, and particularly in the real estate space, we're getting a real estate panel next, but there's a great deal of openness to saying this token represents these rights. And I think that is an area where obviously there's an enormous potential to develop tokens that represent property rights in real estate of a certain type, or that represent an interest in certain specific cash flows. We're not completely reinventing the wheel here. I think we're leveraging off of existing ideas, but given the fact that it can be done in an efficient way, or we believe it can be done in an efficient way, I do think that there's a future for, I think, potentially smaller but targeted offerings that represent very tailored property rights. And I think, one thing going hand in hand with that, and it's a point that my fellow panelists are making, the disclosure rules will still apply. I think that we have to be very clear, and possibly some of the white papers that are out there in the past haven't been as clear as they should have been about what exactly those property rights are and how we can divvy it up. But I do think there's an enormous potential there within the token market.
And you mentioned really tailoring it to what the issuer wants, but we can also really tailor them to what the investor appetite is.
Absolutely, yeah.
What about the ability to fractionalize assets? Does this technology help facilitate that as well?
Again, I don't know that the technology per se is what drives the ability to do it, but I think that the existence of this market, the fact that we believe it's more efficient, that it can be tailored to somewhat smaller offerings than sort of very broad public offerings, all lends itself to doing that, to offering securities or the tokens that represent some fraction of an overall piece of property.
Great. Okay, so we're getting...
if that's the case, if it's a fractionalization of a piece of property, is that token a security? It's really a rhetorical question, right? I don't know that anybody has a clear answer to that question, but I've talked, you talk with people who are looking at real estate. I've talked with people who are looking at fine art, right? I would think it might be kind of cool to carry around a picture of the Picasso in my phone that I own $1,000 worth of. But owning $1,000 worth of a Picasso because it's a blockchain token, I don't know if that's a security or not. Kind of think it's probably not because it's a Picasso. But maybe it is.
Well, what entity is it held in? How are the rights, assigned to the individuals?
We have a test for this.
Right.
All right, sorry guys.
Oranges and the oranges were not securities in Howey, so hopefully the Picasso's not either. But these are some of the really interesting questions that lawyers and others in the space have to grapple with when they're talking about these issues. The example that I always love to give people is CryptoKitties, right? I don't think I've ever heard anybody argue that CryptoKitties were a security, right? But I think I could make a pretty good argument under some readings of the Howey Test and whatnot that the CryptoKitty is a security.
It's definitely the efforts of others. All right, so we're really getting to the end here. Final question is, we've been promised these secondary markets. That's part of the allure of the assets. There's this liquidity they're supposed to encapsulate, but we're not really seeing a lot of exchanges out there for security tokens. Troy, do you have any idea why this might be?
Well, I think we're going to have a panel on that here, so I won't steal any of that.
Don't spoil it.
Of that particular thunder, but it comes back in part to, well, look, the space, depending on how exactly you want to define it, is still new stuff, right? So it's not even as if you think about everything else in our capital markets. We've been doing this for decades to get to where we are. So it's going to take some time. So for things to take 2, 3, 4, 5 years in the regulatory world or in the financial services world, that can be moving pretty quick. Now, I realize that in other worlds and from other dimensions, that's moving pretty slow. But one is just this stuff takes a little bit of time. But one of the reasons it takes time is not only in terms of just the marketplace to get to that point and its own evolution, right, for supply and demand conditions, if you will, overall to line up so that a business idea really can become a business model and actually have a real life and succeed as a business and not be too early. There's a lot of great ideas that are a little too early, so timing from that perspective, just sheer business matters. But it's the regulatory environment as well. which is to be an ATS, broker-dealer, to be an exchange. You don't just decide, oh, that's a label I want, right? You have to satisfy very demanding regulatory requirements. Why? Because the regulators thought that those venues for transacting need to be able to meet certain requirements in order to meet certain regulatory objectives. And so all of that is process and takes time. And so I think as this continues to evolve, we'll see more market participants wearing different kinds of hats and having different kinds of regulatory status enter into the space. I'm sure you'll hear some of that again this afternoon. But I think that kind of in combo accounts for kind of a lot of where we are versus perhaps where others might have thought things would be at this point.
And if I could just jump in, I mean, we've talked about some of the other regulation that could conceivably apply in addition to securities regulation. For some exchanges, if they're contemplating using security tokens that are denominated in Bitcoin or other cryptocurrencies, there is a whole different set of regulation that applies to transfers of cryptocurrencies, the New York Bit license, for example. And so for those exchanges, they have to deal with that regulation in addition to the regulation that Troy mentioned. So another sort of factor that has to be taken into account.
And maybe I'll just throw in one last point from my perspective, which is saying that your token is going to be a security brings a whole bunch of knock-on implications that are even aside from the kinds of things that we've discussed already today. So for example, if your token is a security, every time it moves on your blockchain, that's a securities transaction. So you have all kinds of issues that flow from that fact, including, by the way, whether or not your blockchain needs to be registered as a some kind of trading venue in order to facilitate all those securities transactions. So I think people should avoid the temptation of just saying, I'm just going to do a security token, because it has all these other knock-on impacts away from the trading that occur as well.
So I think it's pretty clear that we are just scratching the surface here. Unfortunately, this fascinating panel does have to come to an end, and I see the coffee break people are coming back in now for the next panel. But I just want to take a moment to thank our wonderful panelists.
Thanks, everyone.